Justice Chandru had given justice to tribal family during his advocacy days using writ petition of Habeas Corpus, and the movie Jai Bhim is made on basis of this case. The movie Jai Bhim, which released recently, had been into lot of discussion where this movie is based on the story of Justice Chandru, where in his advocacy days fought for the tribe called Kurva, and nowadays it is being discussed a lot because the word habeas corpus which is used in this movie, and people have been discussing and trying to understand what does this word habeas corpus. First, let us understand that Constitution of India has 25 parts, out of which part 3 is very important, where part 3 talks about fundamental rights. From articles 12 to 35, it contains a detailed provisions when it comes to fundamental rights. And to protect and enforce fundamental rights, we have very important two articles. One is article 32 and other is article 226, whereas article 32, which is found in part 3, is in itself a fundamental right, where it gives power to Supreme Court to issue 5 different kinds of writs to protect fundamental rights. And whereas article 226 empowers High Court to issue 5 different kinds of writs to protect fundamental rights. Habeas corpus is one of the most widely used and popular writ under our constitution. Habeas corpus in Latin literally means to have a body of, and this writ is used to release a person who is under custody, detained or imprisoned unlawfully. By virtue of this writ, court orders a person to be brought before it who is illegally detained, and it will examine whether his detention was legal or not. If court concludes that his detention was unlawful, then he will be released from the custody. Now let us try and understand under which circumstances the detention becomes unlawful. The first circumstance is when a person is detained without following procedures established by law. That is to say, the procedures established by law under Article 21. In this situation, the person will be released by the appropriate court, either Supreme Court under Article 32 or High Court under Article 226. One of the instances or examples are where a person is detained and not produced before the magistrate within 24 hours, then his detention is illegal. A second situation arises when person is detained when he has not violated any law, and it is very clear that a fundamental rule of our land is that a person cannot be arrested if he has not violated any law. The next and important ground is that when person is detained under a law which is unconstitutional. Yes, if any law which is been held to be unconstitutional by Supreme Court or High Court, under the same law no person can be detained. Whereas habeas corpus cannot be granted or issued against a person whom a court order has been issued by a competent court, and also on prima facie it appears that such order is not illegal or without jurisdiction. In this situation, a writ of habeas corpus cannot be issued against such person. Who can file habeas corpus? A writ of habeas corpus can be filed by the person detained himself or by his family, relatives or friends on behalf of the person detained. In Sunil Batra vs. Delhi administration, an application was made to Supreme Court by co-convict about the maltreatment to the prisoners. The letter was taken up by Supreme Court and it issued a writ of habeas corpus against the jail authorities. And Supreme Court held that writ of habeas corpus can also be issued to protect inmates against inhuman behavior and maltreatment by jail authorities. Hope this video was useful. If so, please share this video with your friends, subscribe to my channel and hit that like button. Thank you. Jai Hind.